Hi, everyone. Thank you so much for being here. Dragged you away from lunch for this. Also really happy to see so many people here. I think it shows that with all of the focus on GDPR, this panel is meant to show it's not the only game in town and that there is something else that exists, that is the only international instrument that's been signed up, is continuing to be signed up, and is still very popular. So I think the geographic diversity of this panel is again a testament to the international scope of Convention 108, increasingly modernized, as you'll find out from the rest of this wonderful panel. Sophie Kwasny from the Council of Europe had actually teamed up with Hiroshi Miyashita to write an article for Digital Asia Hub's newsletter, which I run, on how the Convention 108 was actually relevant to Asia, and it wasn't something Eurocentric. And I think through this panel, we'll also explore with speakers from Uruguay, Mexico, and Ghana, just how wonderful an instrument it is, and what the scope is for improvement, and what the new trends are in this space. So without further ado, I'm just going to introduce you to this great panel. So we have Bruno Gencarelli, no stranger to all of you in this room, who will be moderating the session. Bruno is the head of unit for international data flows and protection at the European Commission. Gonzalo Sosa, who is to his left, is a lawyer at the Uruguayan DPA, the Unidad Reguladora y de Control de Datos Personales. And then we have Fernando Sosa, who is the Director General of the Protection of Rights and Sanctions at the Mexican DPA, which is the INAI. And then we have Patricia Poku from Ghana. She's the Executive Director of the Data Protection Commission of Ghana. And finally, we have Sophie Kwasny, who is the head of the Data Protection Unit at the Council of Europe. So, Bruno, over to you.
Thank you very much, and a pleasure to be a part of this panel. I was asked to, I'm the more Eurocentric person on this panel, so I was asked to explain why, from an EU point of view, Convention 108 is important. And I want just to formulate three brief remarks on that. First, that's where we are coming from. As you know, Convention 108 is an instrument that dates back to the 80s, and it was one of the main source of inspiration, one of the main bases for the EU when it developed its own data protection legislation in the 90s, in particular through the directive of 95. And that continued, of course. It inspired the work we did on data protection in the law enforcement, criminal law enforcement sector, to first the framework directive, and then it inspired our reform in the reform of data protection that will enter into application in few months, the GDPR and the police directive. So that's, for us, it's an extremely important reference point. But it is also an important reference point because that's because, as you said, as you explained, this is less and less a European, less and less a regional instrument. It's a universal instrument. It's the only binding convention on data protection at international level, and we are very happy to see that it's increasingly an international instrument, an international reference point to its increasing international membership. We have representatives here from various continents, various areas of the world, and there has been, especially in the most recent times, more and more accessions or requests from accession from Latin America and Africa. We are hoping also that the Asian Pacific voice, which is a bit missing in terms of membership, but not in terms of observers, and we have seen that South Korea, Japan, and others, and New Zealand, I think, are now observers, which could be a first step towards membership. That's very important because, of course, the convention is not only the convention. I said it's the only international instrument in that on that field, on data protection. It's also the most important international fora where standards are being developed, where best practice are changes, which then often inspire legislation, as it has been in our case. And it's very important because of the relevance of that forward, that there is as broad as possible participation, and we are absolutely, this is a priority for the Commission in the context of also of its application of the GDPR to be absolutely involved and to support the increase in membership and accession to the convention that was expressed in our communication last year on exchanging and protecting personal data in a globalized environment, and that was also expressed very clearly in the communication, the guidance paper that the Commission actually adopted yesterday on the application of the GDPR. And you could see that how those two processes are very closely linked, and that brings me to my last point, which is the importance of the modernization process. As most of you, or all of you know, the Convention 108 is being modernized, and we believe it's, again, an extremely good instrument, which has also, as one very important feature for me, is that it is, as I said, it's binding, and it's comprehensive. It covers processing of data, which is also a very specific and key feature of this convention. It covers processing of data in all sectors, including sectors, for instance, which are traditionally excluded from classical instruments, such as national security, and we know how this is important today. This modernization process is in its very last mile, and I think that we should, and we hope that in the coming weeks we will have a very good news. This has taken, if I must say, a bit too long, and as the one negotiating the GDPR and the police directive, I know how one could be frustrated. It took us also some time, but it's now a time to conclude, and I think the draft which is on the table is a remarkable draft, and it should be adopted. Then, in conclusion, some words of conclusion, I think that the success of Convention 108 shows a bit what we discussed yesterday on the panel of India, that here we are not talking about European standards versus other standards. Here we are talking about universal fundamental right, human right, and universal principles and values, which are, as I said, as we discussed yesterday, based on a common set of an increasingly common and increasingly shared set of principles from, and that's also very important in the convention, from the existence of the setting up of an independent supervisor to a set of enforceable rights, etc., etc. As you know, we are also, when it comes to international transfers, accession to Convention 108 is for us a very relevant, important element when we are assessing adequacy. It's not a necessary element, but I would say it's a very helpful element that really could strengthen and support that process on the EU law. I will stop here, and I'm looking forward to this conversation and to also listening to what our colleagues from around the world have to say on this very important instrument. Thank you.
Well, thank you, Bruno. If I can have my presentation, let's just start by thanking the Council of Europe for the invitation, all the work that Sophie, Patricia, and the Data Protection Unit, and to tell you how pleased we are to be in such a good company of panelists and fellow moderator and chair. But I should begin with telling you a little bit, let's see if it works, a little bit about Uruguay. That, well, geographically is, in European terms, like in the far end of the world. I'm still struggling with jet lag. We have a population of 3.4 million inhabitants, an area of 176,000 kilometers, capital in Montevideo, language Spanish, and this is just to justify if I get lost in translation. English is not my native language. And this is some facts to let you know where we are, but what we stand for. And Bruno recently spoke about certain principles that were common. We stand for common principles with Europe, and we have some numbers that show how we care about our institutions. We have here some, the position of Uruguay, some rankings on lowest poverty, transparency index, democracy index, prosperity index, and transformation index. Uruguay is #1 in Latin America. These numbers are from 2016. And we hold a very good global position also in this ranking, 21 at a global level in transparency, 19 in democracy, 28 in prosperity, and 4 in transformation. So just to give you a very brief picture of my country. But we're here to speak about data protection. And where are we in data protection? Uruguay's unit, Uruguay's law, Uruguay's consideration of data protection as not only consideration, the recognition of the law, that law made about data protection as a fundamental right, was in the year 2008. I was one of the ones that chose to assist to the panel on the Indian code rolling instead of blockchain yesterday. And we, Malavika, much more eloquently than I could possibly do in English, spoke about the fundamental right of protection of personal data, how it is inherent to the human being. So we are humans, so we have this personal right, and the law merely recognizes its existence, but it's a right that I have because because I'm a person. And so this is what the law, Uruguayan law, explicitly stated in its article #1. And since the year 2008, until now, we have been working on that premise. We have some numbers of a survey that was conducted last year in Uruguay in the year 2017 that measured certain aspects on digital government, access to public information, data protection. And we found out that more than 50% of the population of Uruguay knows about the existence of right of protection of personal data. This is a good number for us. We had an increase of 9% since the year 2016. So for us, it was very important. We won't stop here. As you might realize, we are going till we get to 100. And we also found out that 28% of those who know about the right have requested the suppression or modification of their personal data in a database. We have some good numbers also on perception of compliance with protection of personal data. In the year 2016, we had a 55% of perception of compliance, and now we are on the 67%. The people who believe that almost always there is compliance with the law. So I think that we are good. We have a lot to work, though. Why Convention 108? Uruguay was the first non-European member of the Convention, and there are some reasons that we believe that we have to let you all know that made us decide to request accession for the Convention about 5 to 6 years ago. One of them is what Bruno mentioned. This is an universal instrument. This is an instrument that has a global vocation that is not restricted to European countries. Uruguay is the first non-European country member, but gladly there are more, and there are more to come. It also sets international standards based on rule of law, human rights, and fundamental freedoms with common definitions, principles, safeguards, and mechanisms. That's what we were talking about. We are guided by the same principle that the right of protection of personal data is a fundamental right of the human being, and it's part of who we are. It's principle-oriented. It's centered on data protection principles. Uruguayan law is also very principle-oriented. We have certain principles that are also our beacon. There's room for cooperation. There are common grounds for cooperation and different ways of cooperating and to ensure enforcement. We believe on the existence of independent authorities. We are an independent authorities with powers of investigation and intervention. And it gives a common ground for secure transborder flows of information. It refers to adequate levels of protections among state parties. I'm thinking good time. Let's go. Impacts. What were the impacts on a national level of acceding to the convention? Well, of course, on a national framework, there was an impact. There was an indirect impact in the way we drafted our law. Our law is, as I said, from the year 2008. So we consider some of the provisions that the convention established in our law. And we have also a direct impact on our legislation because the law was internalized by a law 1930. So there's another more direct impact of the law. It provided us with an international forum where we can participate in discussions, meetings. The participation on Convention 108 is not only participating on the document of the convention, but also there are discussions regarding certain important issues that are nowadays very important for the protection of personal data. It also generates a network of authorities. The fact that we are all the authorities present in the discussions generates room for cooperation, and it has a certain of replication effects. Many authorities participate in other networks related to protection of personal data. In fact, for example, with my Mexican colleague, we're part of the Ibero-American network on data protection, and we have close ties with the Council of Europe. We have a common language, and I'm not meaning Spanish or French, I mean the language of the convention, homogeneous rules and provisions that apply to all of us. And we got legal certainty regarding, especially, secure transport flows of information and of data between parties. What do we see is the way ahead regarding the convention and the relation with other member parties? Well, we believe that many of these things were also addressed in the modernization that Bruno was mentioning. The need to include new principles, the fact that the convention is from the year 1981 and the additional protocol from the year 2001 required a modernization effort that was very hard, but it's in a very good stage. Perhaps Sophie will speak about that later. To include new principles, ways to ensure compliance of members. Well, we need to ensure compliance of members not only at the moment of acceding to the convention, but throughout the participation on the convention, to ensure also that the flows of information are secure. Extend cooperation mechanisms. We have to have other mechanisms of cooperation. Recognize other rights of the data subject that were established in the convention, or extend the ones that exist. And, of course, clarify rules for adequacy of non-parties. Perhaps they can speak later about this, but I can do a transfer if there's a third party, non-member of the convention, but if there are certain rules that establish the adequacy of this country for the information, so those rules have to be clear. I'm a little bit out of time, but I just take 30 seconds to tell you that, as I said, it's the 10th anniversary of the PDP law in Uruguay. We are holding a series of celebrations, conference, and workshops from the 8th to the 11th of May of 2018 in Montevideo. And I'd like to extend out the invitation to participate, either to go to Montevideo or to participate through the internet. I can't promise you that sunset, but I can promise you a deep discussion on PDP. Well, thank you.
Good afternoon. Hi. I am very pleased to meet you today at this conference and to participate in the panel with my colleagues. It is a great opportunity to reflect with you today on the benefits that, from the Mexican perspective, will represent the accession of my country to the Convention 108 and its additional protocol, both related to the automatic processing of personal data. In Mexico, in the Mexican legislation on personal data protection is based on the recognition of the protection of the personal data and privacy as human rights. These rights are established in the Mexican Constitution. The right to privacy is also recognized in the international instruments, such as the American Convention of Human Rights and the Universal Declaration of Human Rights. The development of new information and communication technologies, as well as the services developed to exploit the benefits of the digital economy, imply the exponential growth of the cross-border data flows. This requires the establishment of bases that facilitate and enable states, governments, companies, investors, and other actors involved in their capacity as exporters to make international transfer or personal data, safeguarding the rights of data subjects, both natural, personal, and legal entities. In this sense, for Mexico, the signing of Convention 108 and its additional protocol entails a series of political and economic benefits for my country. And of course, it benefits Mexican citizens themselves. By reinforcing their human right to privacy, it also benefits all the people because they have to able to exercise with full freedom and without any restriction the right to the protection of personal data in Mexico regarding their commercial, cultural, and social relations in general, without exception or limitation due to nationality, place of residence, origin, gender, or any other aspect. This certainty be reciprocal for Mexicans in the territory of the states parties. With the signing of Convention 108, an international space will be created between Mexico data protection authorities and those of these state parties. This, I think, could be convenient because it fosters the solidification of many aspects, like the effective application of states parties' national legislation on these matters, assistance between control authorities related to claim of data subjects in the respective investigations, as well as the exchange of information within the scope of the activities of the authorities. The exchange of the best practices and experiences on personal data protection, particularly in sensitive areas such as children personal data protection, health, social networks, and the impact on the right to the protection of personal data. Regarding the economy benefits from the accession to the convention, I would like to point out among the most significant that the states party companies could transfer personal data to Mexico without the previous authorization of the control authority. This will have an impact on the following aspects: the growth of foreign investment in Mexico with the establishment of companies from different sectors, raise the level of market efficiency of Mexican companies and those operating in Mexico. This will raise the quality of their products and the service offered in the national and international market. The free flow of personal data will consolidate Mexico commercial relations with the states party, the growth of direct and indirect formal jobs. Certainly, will be reinforced in Mexico and in its commercial, educational, scientific, and humanitarian relations, both in the public and the private sectors, as well favoring the digital economy by having a standard framework that facilitates the international transfer of personal data in secure manner. I would like to conclude saying that in Mexico is a great opportunity, and this opportunity brings the Mexican other scope to protect their data protection and their rights. The rapid development of information technologies warrants the need to adopt global or regional binding instruments in this area, such as Convention 108 and its additional protocol, aiming at establishing a single standard as well as laying the foundation to implement mechanisms that facilitate the international cooperation among supervisory authorities. Thank you.
Good afternoon, everyone. So my name is Patricia Poku. I'm the ED for Executive Director for Data Protection at the Ghana Government Data Protection Commission. I would just want to give you a bit of background about me and then give you some report on Africa and then focus on what's happening in Ghana. So I've had the double advantage of developing my privacy career in Europe. It's grown on me from the early 90s when it wasn't well known. Data protection wasn't a household name, and then it became a household name. And then EU GDPR came on, and I had the advantage of being part of all the preparations around the EU draft regulation and the 3,000 pushbacks until it was eventually effected as law. And up to last year, July, I was heavily involved in training GDPR practitioners. So I was running consultancies, helping organizations do their gap analysis across Europe. And then I was invited by Ghana to come and support their data protection work. So it was a big decision economically for me. But also, I like the idea of a nice new big challenge, new terrain, greenfield implementation, the challenge of not knowing what to expect and how well into it they are, and all of that. So I packed not knowing what I was letting myself into and went to live in Africa. So across Africa, I've begun networking with other African commissioners, my peers, trying to understand the African level issue and challenge about why do we have to do data protection at that level, and what is the implications on businesses locally, and how do we meet the challenges it presents. And the group of data protection commissioners in Africa have formed something called the African Dialogue on the subject. We've met about 3 or 4 times at big conferences such as this. Last year's Ghana conference, Tunisia's conference, and then earlier this year at the Conference of Information Commissioners, we met as a group, beginning that conversation of trying to understand what it is that we are trying to achieve. But the important thing you find is that it's become so important and a priority for most governments now because of the EU GDPR and its requirement and the way the EU GDPR law has been laid out. Fortunately for me, just before I was preparing consultants here in Europe for EU GDPR, I was global director for an NGO called World Vision International, which meant that I had to understand multi-jurisdictional legislation in about 95 countries. That meant that I had to read and understand several data protection laws. And it became very clear that most countries outside Europe had lifted the draft EU regulation and as a template for modeling their local laws after, and Ghana seemed to have done the same. And so that has pros and cons. The good thing about that is that it's more or less like the European GDPR. You find there's just change of wording here and there and calling the same thing another word. And so in terms of interpreting the law and understanding what it's trying to achieve, it's the same, more or less. But the challenge that brings is that we have set ourselves a very high standard to meet, where data protection has grown slowly and built up in Europe up until what it is now. In Africa and other Asian countries and third world countries, it's become something that we are trying to achieve, a change of culture shock in terms of implementing even business management, documentation issues, records management, all the problems that Europe has taken time to build up is now raw and needs to be met and addressed in order to meet our international obligations. So African data protection commissioners have begun this conversation of how we bridge that gap of skills deficit, knowledge deficit that exists, and the actual funding of the program implementation challenge that exists. Though it's amazing to understand the determination and commitment that the key decision makers and the lawmakers in these jurisdictions are to making it work. It brings me to the question of why join the Convention 108. So with the effort that we have to make in order to establish a program of this nature, the advantage here is that there's not that problem that we had in Europe of bad habits dying hard. It doesn't exist. We are introducing something new. We are building it from nothing. And so on that front, it's easy because we are showing them from best practices adopted from Europe. And also to introduce that consistency that conventions like the Convention 108 brings as evidence of the best practice and the agreed standards of how to make it work. And for us around Africa, united and agreeing that this is the way for this, how we're going to agree to, we're going to implement it across, it's making it easy for us because we are doing it the same way with similar roadmaps, with slight jurisdictional differences and cultural differences and jurisdictional specific challenges that it presents. So for us, it's very good that we have something like the Convention 108 that, I don't know how many African countries have, there's Mauritius and Tunisia and Senegal. You'll find that in Africa, the Francophone, French-speaking African countries are well ahead of the Anglophone, English-speaking African countries. I don't understand why, because Europe is French and English, and Europe has had similar pace of... Yeah. So I'm not sure how that has happened where countries like Mauritius and Tunisia and Senegal are more into it than the rest of us. But now in Africa, Ghana is the lead in terms of the Anglophone English-speaking countries making strides in trying to implement the requirements of data protection law and making it stick. We now have a commission set up. We have an office location that you can, acknowledge. We have me, a commissioner who has some know-how and understanding and trying to push it and raise the banner. And then we have a whole country of determined data subjects wanting to exercise their rights and pressing for awareness and sensitization and the need to get support, top-level support to also exercise their rights. So everything is happening together. We have countries like South Africa who have now passed the law and in the process of establishing their commission. We have a country like Nigeria who has a bill in parliament, and other countries now observing to follow suit. To help all of this, there's the AU Convention that has now endorsed the need for African countries to pass data protection law. There again, you find that it's modeled after the EU requirements. And to layer that, there's the ECOWAS, which is the countries in West Africa Supplementary Act, that is also endorsing the need for each West African country to pass their own data protection law. And about 3 months ago, we were asked to submit a state of affairs report to ECOWAS to explain how far we are, what the issues and challenges are. So there is that external landscape push for it that mandates the state level leaders to also stick to the plan of making data protection work and be like Europe, something that every country needs to do. So it's a very exciting time on the African terrain. Within Ghana, we not only have become observers on the Council of Europe, but we are participating actively on the international front. Already for cybersecurity, we're working actively with the Council of Europe, and now we are looking to also start active work on data protection with the Council of Europe. Also looking at other international organizations that we will be part of. So we are doing the groundwork locally, state level implementations, and looking at what's on the external landscape to us, and wanting this conversation to continue. One big challenge we had was that knowledge deficit and the lack of practitioners to do the work that needed being. So in the last few months, with what my experience was in Europe and a few consultant friends I had here, we put the manual together based on the EU GDPR requirements and material that we used to train in Europe, converted that into Ghana law speak, and we have trained our first 25 practitioners to European standard. They will be receiving their certificates in a big celebration on next week, Global Data Protection Day. We've invited about 150 CEOs across Ghana, local-based and multinationals, likes of Google, Facebook, and all of that with the branches in Ghana, to be present to endorse that push for to encourage all other organizations in the country to also nominate an individual to be fully trained. And we hope that this year we will focus seriously on training practitioners and churning out more and more practitioners into the system. And by this time next year, have a room full of practitioners like this to also run a local Africa-based data protection conference, to which all of you will be invited to, I think, I hope. And then to establish that African data protection local certification. And then the next challenge is to have that international acceptance of that certification that is African-based. So that's where we are headed going forward. Thank you.
Thank you, Patricia. Sophie, I understand that you're going to flip from being a speaker to also being moderator for the second half. So you'll pose follow-up questions? Depending on time, yeah.
Yes, I have a slide presentation. So good afternoon, everybody. Bonjour, Sophie Kwasny du Conseil de l'Europe. Donc it's a pleasure for me to have everybody on this panel. So due to the short time I have allocated, I will go quite quickly in my slide, and I think it's nice to also have follow-up questions to the speakers if we have time, and audience interventions. So a quick update on the convention, and first thing I need to highlight about the convention, everybody, all of us call it Convention 108. It's the Council of Europe Convention on the protection of individuals with regard to automatic processing. And why I highlight this, it's because plenty of other conventions of the Council of Europe, and we have over 200 conventions, are called European conventions. For instance, European Convention on Human Rights, with the focus on European. Here with this convention, since the beginning, the European restriction and limitation wanted to be avoided by the drafters, so you don't have it in the title of the convention. So the convention was open for signature on 28 January 1981, 28th of January indeed, which is Data Protection Day now celebrated worldwide. And we now have 51 parties. So you have the list. It's the 47 member states of the organization, 47 countries, plus 4 on the screen, Uruguay, Mauritius, Senegal, and Tunisia, that are bound, that have exceeded, and indeed Uruguay was the first one in 2013, leading the way. We also have a series of other countries that have been invited to exceed but have not yet finalized the ratification procedure. That's Morocco, Cabo Verde, Burkina Faso, Argentina, and Mexico. So indeed more African countries, but not all of them yet bound by the convention. And if I can respond to Patricia's question about why all those Francophone African countries, I think that what was instrumental in promoting Convention 108 in the Francophone African countries was the association of Francophone DPAs. That is a very active network of Francophone DPAs. And you see that's how we actually reached out to Mauritius, Senegal, Tunisia, and Burkina Faso. We also have, and it was highlighted, quite a number of observers that participate in our work in Strasbourg in the committee. And so it makes actually a group of over 70 countries that are present and participating in our work in Strasbourg. What is quite interesting also to highlight about this group of countries is that there is no duplication with the International Conference of DPAs, because it's not solely DPAs. We also have countries that are represented by their government. So it's quite an interesting mix and dynamic in the negotiation of legal norms. I also would like to make the link with the OECD, and I see Michael Donoghue there, because actually it's thanks to the OECD and its guidelines that were adopted in 1980 that the Council of Europe in its work benefited from expertise from countries that were negotiating the OECD guidelines in Paris. So Japan, US were there, and they were coming to Strasbourg. So the drafters of the convention since the beginning were really with this mind of having countries from all regions of the world joining, and it's only now in the recent years that this potential is actually being realized. So Convention 108 today, this is this old lady trying to adapt to the technologies with her phone. It's a 1981 lady, so 37 years old. I don't imply that 37 years old ladies look like this. Myself being above that age, I don't expect to look like that, but still. And on the right, you have what will be Convention 108 tomorrow. We are modernizing, and Bruno mentioned it. It's a long work. It's been 7 years we've been working on it, and we hope to deliver very shortly a modernized version of the convention. So I will not go into great details for lack of time on the modernization, but just to highlight the main objective was really to reinforce the individual protection, trying to apprehend challenges posed by new technologies, for instance, but in that exercise continue to promote the convention as a universal standard. You've heard it, there is no equivalent, there is no international treaty on data protection else than the convention. So this, in the work of revising the convention, was really kept in mind by the experts, and all the drafting proposals were considered like, okay, could this region of the world adhere to this principle? So it was really one focus of the experts. And also preserve the general, simple, and flexible nature of the convention. If you look at the text of the convention, you will see over 20 articles, very straightforward and simple. And maintain coherence, consistency with other relevant legal frameworks. And here, it's the key articulation between the convention, other frameworks, and in particular the one of the EU. And we've heard how important it is for the EU in terms of adequacy, in terms of relation with the non-EU member countries to have the convention. So I've just put there the structure of the modernized convention. Basically, all aspects of the original text have been modified, have been upgraded. Some parts were not touched, for instance, the definition of personal data. And yesterday there was a panel very interesting on this. And this is one of the sole aspects of the convention that was not touched in the exercise. You have a long series. Some aspects are completely new in the convention. Transparency, for instance, the part on additional obligations, which brings in privacy by design, privacy by default, accountability, PIA, that's all new. And I've put some signs next to 3 topics, exceptions, transborder data flows, and convention committee, because it's actually the 3 points where we have had to negotiate very eagerly for the past years. exception, so it's the derogations to the convention, in particular derogation for national security, that was very eagerly discussed. Transborder data flows, the negotiation was regarding particularly the EU framework within the convention. We have at the moment in the 1981 convention a principle of free flow of data between the parties, but we all know that since 1995 with the directive, EU member states that are bound by the Convention 108 can no longer export freely to other parties of the Convention. If I take Russia, Turkey, Azerbaijan, for instance, and even Uruguay, well, it's not a good example because you have the adequacy, sorry. And the last point, which has been eagerly discussed, is a technical point about the voting rights in the committee. And there again, it's about EU relationship in the Council of Europe and the weight of the EU as 27/28 in the decision-making power of the committee. And the committee, which is adopting legal standards, you can imagine that it's quite important to ensure that there is no dominant voice in the committee. So legal form of the instrument, and it's quite a key question, where are we? We had proposed since the beginning an amending protocol. So the proposal is on the table. We should know by tomorrow evening, actually, because this draft amending protocol has been submitted, to a silent procedure. So tomorrow night we will see or not if the text is accepted. The difficulty with the amending protocol, and that's standard treaty law, is that for an amending protocol to convention to enter into force, you need all signatories to the convention. So here I mentioned 51 to ratify, sign for the protocol to enter into force. And you can expect that this will be taking some time. If there is an objection by tomorrow evening on this draft, the diplomats that are now working on it, because it's at the level of the Committee of Ministers, so it's Ministries of Foreign Affairs, they have already announced that if we cannot go through with this amending protocol, we would take the text as it is and put it in a new convention, a revised convention, but then we would have to start again from scratch with ratifications. So hopefully by next week we will have more to tell you on this. Just I wanted to highlight, and I think it's very important, the 95 directive in its preamble in recital 11 very clearly translates the link between the convention and the EU framework. The EU framework gives substance and amplifies the principles of Convention 108, and I think it's a pity that we lost that in the regulation. Because the regulation is actually only expressly mentioning Convention 108 in recital 105, and so it's linked, like Bruno mentioned it, to the question of international data flows and adequacy. It's one of the elements that is taken into consideration. Bruno mentioned it, and it's very good to hear it when it's the European Commission recalling it, that Convention 108 is the mother, is the source of the EU data protection law. That was last year on the occasion of Data Protection Day. I will go through this because Bruno mentioned it. It was this document issued by the Commission last year and actually really recalled yesterday with the guidance that was issued. Just to illustrate the work we're doing in the committee in Strasbourg, there's a variety of topics addressed by the committee by those 70 countries that were together, and that's also something I want to highlight. Only 51, the parties, have the right to vote, but those of you who have been coming to Strasbourg and witnessed it, it's very open in the format, and anyone, observers or not, can contribute to the work. So a practical guide on the use of data by police that translates our recommendation on this topic is now being finalized, and we're working on an update of our medical data recommendation, which would be a recommendation on health-related data. You can find our work program online too if you want more information. So I thank you for your attention. I will look forward to questions too. But so while I have the microphone, if I can come back to some of the speakers, asking them for follow-up questions. And I'll start by Gonzalo, please. Gonzalo, Uruguay decided to request accession to Convention 108 at the same time as it went for the adequacy of the EU. You're the only country that did that. I make the link also with Argentina, because now that they've requested accession, already having an adequacy, I'd like to know why, as an adequate country, you would also consider Convention 108.
Well, I think that it goes back with, we were talking a while ago about providing our citizens with the best protection available. And that includes, of course, ensuring a secure framework for international transactions, and the fact that the convention also, as I said, is also based on the same principle of the protection of personal data as a fundamental right. It was the logical thing to do. We have also a very mature, very evolved digital policy in Uruguay, and well, this panel is about convergence of data protection models, but we are in a conference that is about convergence of technologies and protection of personal data, and there are interesting synergies between the digital government and data protection in Uruguay. The data protection law in the year 2008 was enacted after we saw after the deployment of the digital strategy, and after we saw that the regulation on protection of personal data that we had in Uruguay before wasn't enough, only referred to credit scoring, etc. So we wanted to provide a national framework that ensure our citizens the best available protection. And we also wanted to provide a national framework that would ensure the possibility of transborder flows of information when transborder flows of information is as simple as clicking on your cellular or cell phone or on your computer. So I believe that are the reason. The European framework, the directive and the convention provided us with certainties that we needed to ensure that protection.
Thank you, Gonzalo. Fernando, if I can ask you a question too. So after this step of accession of Mexico to Convention 108, what is the next big objective of Mexico in terms of data protection?
I think the great next step for Mexico and other countries is create a culture to protection of data, because an instrument as the Convention 108 is not only a legal instrument, it's a cultural instrument, a standard. And this is the great step for Mexico. Understand the law not only for the informants, and understand the protection data as a culture. This is the great step for Mexico.
Thank you, Fernando. Patricia, we've heard how dynamic Ghana is in the region. You mentioned the Treaty of the African Union. You mentioned ECOWAS. So, as the Commissioner of Ghana, what is your foresight, and what are the actions you will be taking next on this international scene?
Okay, so Ghana has quite a lot of privilege being the first Anglophone country taking this step into data protection. And with the commitment we have to making it work, especially as we're a bit behind our Francophone peers, we have been nominated. Not only have we applied to accede into the Convention 108, but Ghana Commission is co-chair with the UK ICO for all Commonwealth countries. So we're working on that common thread network for Commonwealth countries. I think it's about 36 countries. Don't quote me on that. But Commonwealth countries are now coming. It's something that we're working on, 50, right? Sorry? That's okay. So, well, we are working together on the Commonwealth network to also promote data protection on that front. Then we have the African dialogue, where the last time we met in Hong Kong with the other commissioners discussed the challenge of the language barrier and nevertheless, the willingness of all parties involved to work together and not separately. Ghana, again, was nominated, being myself, as the Anglophone lead. for Africa. So my work is cut out, not only to focus nationally, making data protection work on the ground in Ghana, but also to lead by example to ensure that when other Anglophone African countries pass their laws, that I will encourage them, my peers, to do it the right way. It makes sense that everyone is meeting the EU standard, that we all set ourselves that consistent standard, and hence my excitement about Convention 108. So it's not Ghana doing something that everyone must comply with, but it's an international standard that several countries have set themselves to meet, and to use the standards from there as the exemplar for other, and to encourage and motivate other Anglophone countries to do the same. Reason being that we have all acknowledged that the international flow of data is such that one country can't remain compliant on its own without encouraging other countries, especially in their jurisdictional neighborhood, to do the same. And so my passion is to make sure that I do it right locally. And the Ghana president, I don't know if you guys saw the thing that went viral. You saw it and told me the Ghana president is very committed to changing the mindset of Africa and Ghanaians, and the vision of making Ghana the gateway on several fronts, including data protection. And then standing up as its own independent country, doing the right things and changing the African mentality of doing things ad hoc, and to do it the right way, meet the international expectations. So Ghana is projecting itself as the gateway for Africa. And so with that mandate, that has become my commission's kind of priority, to also position ourselves in a way that allows other African countries to learn from good practice adopted from the international best practice locally, and also to help them also do it the right way, so that together we are standardizing the operationalization of data protection requirements across the globe. So that's my priority.
Thank you, Patricia. We have about 12 to 15 minutes to have questions, and I wanted to thank Sophie actually for putting together the new face of Convention 108. I think the diversity of this panel really represents the international scope, and you wanted me to just throw in a couple of things on Asia being on the panel, so I just wanted to say, I think you'd put out the provocation earlier that if Japan and Sri Lanka are already parties to the Cybercrime Convention, why wouldn't they sign up to something like 108 to also protect human rights while they police the internet? And I think there's a very simple way to start participating, by observer status, as you mentioned. So Korea and Indonesia have already been granted observer status, are already seeing the benefits of interacting with the Council of Europe. And I think for those who aren't convinced yet, Graham Greenleaf, who is a data protection instrument all by himself, wrote a really great, there's a great slide deck on the Council of Europe website about all the benefits of Convention 108, and a couple of things I'll just mention before throwing it open, which didn't kind of fully come out, is that it's really the only realistic prospect of globalization, given that it's actually nearly 50% of countries with data privacy laws. And in a very sort of droll way, he says, well, there really is no realistic alternative. There's nothing else of this scope and scale. No other binding global agreement actually exists. There's nothing else on the horizon. And this idea of interoperability with any other instrument is usually illusory and often illegitimate, in typical Greenleaf style. And I think also to stress the fact that it is voluntary and that it's reciprocal. I think that's a really, really big drive. And it is effectively the standards that countries outside of Europe have been implementing bottoms up anyway. So I think there is that in its favor. And countries don't have to decide on what national whitelists might look like and what adequacy and sufficiency look like, that the 108 list can actually function as that. So with all of these benefits, I think I'll just throw it out to questions from the audience. There's a mic here for people who'd like to come up here. Thanks. Please.
This works as well. I promised Sophie a difficult question, so I have to deliver now. I have a couple of questions, actually. The first one is for Sophie about Modernized Convention 108 and the provisions around international organizations potentially acceding. I was just wondering if it was possible to hear more about the background to that. Was it the EU that was envisaged? Was there, or is that part of the more global intention to reach out? Then that would lead to a consequent question on to Bruno to see what the approach of the EU would be to that, whether there is an interest in, or it's contemplated as a possibility. And then the second question would be, I'm not really sure if I thought it through properly, but the assumption in the GDPR, or the provisions actually in the GDPR, are envisaged that it is a very positive thing if a state that is applying for or is being considered for adequacy is also party to the convention. But I was wondering whether there might not be some complications that are unexpected, potentially arising from Article 44 of the GDPR, that envisages also onward transfers to be considered as a factor to be taken into account. So, for example, if a party if a state becomes party to the convention, there is a presumption that free flow of data is encouraged, and at the same time, the same country is applying for adequacy and is being considered for adequacy. Could Article 44 not give rise to complications? So free flow of data with all the members of the convention, including potentially countries that do not have adequacy, being considered as a negative element in the adequacy assessment. I'm not sure if I made it clear.
I'll start responding on your first question about international organizations. I don't think Bruno will accept that this qualification applies to the EU, but indeed in the work we started with the EU, having the EU in mind as enable accession by the EU to the convention, and it's not a new idea because we already have actually another amending protocol, but which never entered into force, aimed at enabling the EU to accede to the convention. So we started with that in mind, but then in the work we have Interpol participating in our work. We have the ICRC now, since recently, and so naturally having the EU there at the table and thinking, okay, maybe it would also benefit to other international organizations to accede to the convention. We naturally had first possibility for the EU to accede and then open up to other international organizations. About the adequacy question, I think I will leave it to Bruno to respond.
Well, first of all, I don't know on which point I'm supposed to disagree with you, because indeed we are, under international law, we are an international organization, and we are very much looking forward to accede to Convention 108, because in reality, that's because of question of internal competence and the fact that it's the EU which exercise the international competence of its member states in this area. We are already very active in Convention 108, so the accession of the EU would just formalize something that already exists. And of course, we have nothing, neither I have to express any position on that. We are for as universal as possible membership of Convention 108, so if other international organizations would meet the standards and would be interested, we would certainly view that very positively. I think as the question came from the Red Cross is a bit of a special animal, because in terms of its statute and its whether it can be considered an international organization within the meaning of international law, but that's not open that discussion here. But certainly we are absolutely supporting the broadest possible participation in Convention 108. As then it comes, I'm not sure I fully understood the question. But certainly, as I said, it's a very important element that we would take into consideration for adequacy. Then there was a question that was related to onward transfers. As we know, adequacy is not the only basis for transfer in EU law. There are other bases for transfer. And actually here also, there is maybe an added value or role that Convention 108 can play. And that's also the question of, whether I don't see the adequacy route and Convention 108 route as excluding, as mutually exclusive. On the contrary, I think they are absolutely complementary, and for many reasons. First of all, because I think in those type of conference, we often hear this, we need international standards in data protection. Well, they already exist. It's Convention 108. We need a convention on data protection international. Well, it already exists, and I think it's even more important today because, as the EU example shows, we have a increasing scrutiny, judicial scrutiny, political scrutiny on international transfers, and we need to have a probably long-lasting solution. We need hard law solution in terms of data protection and in terms of transfers. And a convention like this one is absolutely an essential tool in that context. Thank you very much. And is an essential tool in that context. And the second question, and the second aspect of that is that, as we said, Convention 108 is not only a convention in terms of a piece of paper. It's also a process. I think the role of the committee, by the way, has been strengthened in the Modernized Convention. And it's at a moment where, for the reason I said and others, there's an increasing demand for international standards and the development of international standards in the area of privacy, in the area of data protection. Being a member of Convention 108 in terms of forum, in terms of process, means having the possibility to participate, to shaping those standards. And that's also very important, I would say. And we always forget, but we tend to not sufficiently consider that I would say, that dynamic element.
Thank you. So it's great to see people in violent agreement for a change. We have 5 minutes to take 1 or 2 more questions if people have any. Otherwise, I'll turn to them for closing remarks.
Can I just, Malavika, if there are no questions, I want to come back on what you said earlier.
Yeah.
On this.
No. Okay.
If someone stands up, I will stop. But the link with the Cybercrime Convention, I think it's very important to highlight it. The Cybercrime Convention has 56 parties. But what is interesting is that not all Council of Europe member states are parties to it. So actually the non-Council of Europe countries that have ratified the Cybercrime Convention are actually far more than what we have in Convention 108. But so of course, any participation as Secretariat we do in the committee of the Cybercrime Convention, we keep on recalling to those countries that have signed the Cybercrime Convention and not the Data Protection Convention that it's a sister convention. It's the same. It's open to them, and they should come. And indeed, you mentioned Sri Lanka as an example, and I think it's a good example because to become observer in the committee, which is a first step, like for Ghana, you don't necessarily need to have a law or a DPA like Sri Lanka precisely. So this is something to highlight. In any contact with any countries in the world, they can come and participate in the work as observers, even if they don't have data protection.
Can I add something on that? Because that's I wanted to mention that as an extremely important point. I think that, again, very recent developments show how much these issues are interlinked, the interaction between cybercrime, digital evidence, access to evidence, and privacy issues. The US Microsoft Supreme Court case is an example of that. And that shows how, in a certain sense, to walk in that context, you need 2 legs. And one is the Cybercrime Convention, and the other leg is the Convention 108. And certainly, we see these 2 conventions as complementary, especially in light of the most recent developments and how, because of very lawful law enforcement needs and because the developments of the digital world, you need indeed ways to access certain type of evidence. But that cannot be done without certain privacy safeguards. And Convention 108 can also play that role. Plus, we are in an area where often, rightly so, stakeholders are stressing the risk for creating a conflict of laws. The more we have countries acceding to those two conventions, the more we can at least contribute to addressing this issue, which is a very complex issue. But that combination is I think, an important one and an increasingly important one. Yes, essentially.
I think that's a great moment at which to leave this panel. So I want to thank all of the panelists and all of you for being here. Thank you so much, Bruno, Gonzalo, Fernando, Patricia, and Sophie. Thank you.
Malavika.